Picture this, you just closed on your new home, excited to move in, but when you walk through the door, the seller's left behind old furniture and junk, and you thought, wait, what can I do about this? Maybe you had a buyer suddenly get cold feet, and the earnest money just wasn't enough to cover your losses. Or maybe you're the buyer, and the deal falls apart, and the seller is claiming they should get the earnest money. Situations like these happen all the time, and the first person most people think to turn to is their realtor. But here's the thing, sometimes the answer goes beyond what your realtor can legally help you with. Hi, I'm Shirley, a Minnesota attorney and realtor. In this video, we're breaking down earnest money disputes, not just your basics, but how Minnesota law actually applies when a deal falls apart because of one misstep, one poorly handled cancellation, or simply missing a deadline. These things can just cost you thousands, so keep watching to see how we can prevent that from happening. Now, before we dive in, just a quick disclaimer. This video, it's only for informational purposes only and should not be treated as legal advice. However, if you're in need of legal guidance or you're looking to buy or sell a home, feel free to reach out to me. I'd be happy to help. You can find my information at the end of this video. All right, let's jump right in. First, what is earnest money? Simply put, it's a good faith deposit that a buyer puts down to show they're serious about purchasing a home. Now, that money usually sits in the listing broker's trust account and gets applied to the purchase price at closing. But what happens to the earnest money if the deal falls through? When both parties, the buyer and the seller, claim that they're entitled to the money. Understanding the law and proper procedures can make all the difference. Now let's discuss how an earnest money dispute can play out in Minnesota. Say you have a buyer and a seller. They agree to the sale of a home for $300,000 where the buyer puts down $9,000 in earnest money. The purchase agreement also includes a financing contingency, giving the buyer 30 calendar days to either secure a loan or cancel the agreement if they can't. On day 30, the buyer's agent leaves a voicemail for the seller's agent, stating that the buyer just couldn't get financing and now wants to cancel the purchase agreement. So after midnight, the buyer's agent follows up with an email saying the same thing. So who should get the earnest money? First, let's look at the facts. We know that we have a purchase agreement for the sale price of $300,000 with the 3% earnest money. The buyer had 30 days now to secure financing or cancel to get that earnest money back. Now, there was a cancellation on day 30, but that was with a voicemail, and the written email didn't go out until after midnight, meaning that was day 31. Under Minnesota law, verbal cancellations don't cut it. The statute of frauds requires real estate contracts, including cancellations, to be in writing. And as for that email, the deadline was missed. It was a little too late, and courts take deadlines and purchase agreements very seriously. So since the written notice didn't go out on time and the buyer defaulted, the purchase agreement, it's still in effect. The seller can start the statutory cancellation process, and if the buyer doesn't cure the default, meaning obtain financing, the seller gets the earnest money. So in this example, even though the buyer made a good faith effort to cancel, they didn't follow the correct legal procedures or timeline, and that mistake costed them $9,000. So what if the buyer thinks that they should get the money back? Well, if that happens, the earnest money stays in the broker's trust account until there's either a court order or settlement agreement. It just can't be randomly given out to either of the party. So then how could this have gone better for the buyer? Well, first of all, waiting until the very last day to cancel was the biggest mistake. If you already know that financing might not work out, you really just don't want to wait. Don't take the chance on that. You can always cancel early in writing, and if the loan comes through later, you can make a new deal. It's way safer than trying to pull it off at the very last minute. Second, that voicemail. Yeah, that doesn't count. In Minnesota, cancellations need to be in writing. That means a signed cancellation form, a letter, or at the very least, an email before the deadline would have worked. If the buyer had just sent the written cancellation by 11:59 p.m. on day 30, the buyer could have gotten that $9,000 in earnest money back. But because they were late and didn't follow the proper steps, the seller gets to keep it. So the bottom line here in real estate, meeting deadlines and written notices, they really do matter. One misstep, that can just simply cost you thousands. So there you have it. That's the end of this video. Thank you so much for watching. And again, if you are looking for legal guidance that you can trust, looking to buy or sell a home, or really just have some real estate questions, reach out to me. You can find my information at the end of this video. Thank you so much for watching. I'll see you on the next one.